So it was coercion. It was using policy as a way to coerce people, extort people into taking a jab or lose their job.
Our vaccination rates are not high enough, and we need to protect those who can't protect themselves. People have had ample opportunities to get vaccinated, but there are still too many people who are choosing not to protect themselves and others. We know that there's a very small percentage of people who can't get vaccinated. There will be a process for you to prove that. But for the rest, the time is up, and there will be a clear choice before you.
Tamara Ugolini here for Rebel News, and in today's report, we're going to hear from two ladies affiliated with the Citizens Alliance of Nova Scotia. It's a grassroots organization comprised of professionals, educators, and families dedicated to informing the public about government actions, decisions, and policy. As a federally registered nonprofit organization, they strive to protect the human and constitutional rights and freedoms of Nova Scotians. In October of 2021, they filed a judicial review after severely repressive actions were issued by the provincial health officials in response to COVID-19, namely the harshly imposed vaccine mandate system, which they say was unreasonable and beyond the scope of the province's Chief Medical Officer of Health, Dr. Robert Strang.
And we will see some breakthrough cases in people who are fully vaccinated, but their risk of severe disease and hospitalization is extremely low. Breakthrough cases are expected and are not a sign that the vaccines don't work. For the Premier, Minister, and I, the coming weeks will be about finding the right balance between opening and public health measures. And we may have to make corrections along the way. For Nova Scotians, it will be about finding the middle ground between being fearful and being complacent.
Dr. Strang, as well as Health and Wellness Minister Michelle Thompson and Brad Johns, the Attorney General of Nova Scotia, are the three named as respondents in this case.
These individuals must show proof of vaccination. If not fully vaccinated, meaning 0 or only 1 dose, they must participate in an education program, and they have until November 30th to become fully vaccinated. If an employee is not fully vaccinated by November 30th, they will be placed on unpaid administrative leave. Government will not provide additional funds to these sectors to pay for these administrative leaves.
The board members of the Citizens Alliance of Nova Scotia, acronymed CANS, Samin and Tara, join me now to elaborate on this case.
The main goals of the review are to show ultra vires, which means that the legislator, in this case the Chief Medical Officer of Health and his supporting team, I suppose, acted outside of their authority, their legislated authority. Mm-hmm. So that's ultra vires. The other aspect is bad faith. So Nova Scotia's Health Protection Act is unique, as far as I understand, in that if the Chief Medical Officer is seen to be acting in bad faith, as in not in good faith, then he or she loses immunity. So that is that's something that we're saying that was done, that there was bad faith, there was prior knowledge before anything was mandated around, at the very least, safety and efficacy. Yeah, that's the main goal of the judicial review.
What we were trying to point out with Section 53 was that public health emergencies can be declared within the Act itself, there was no need for a state of emergency to be issued. And within that section, it's Section 53(2)A. It talks of a voluntary immunization program, which, I mean, what we submitted for the judicial review was, anything but. So it was coercion. It was using policy as a way to coerce people, extort people into taking a jab or lose their job.
The group further argues that Section 53 of the Nova Scotia Health Protection Act was not upheld, specifically where it states that the chief medical officer may implement special measures to mitigate or remedy a declared emergency, but that emergency must be declared by the Minister of Health, something they say didn't happen.
We were supposed to get the record, which is the evidence that was used to put the order out. We were supposed to receive it within 5 to 10 days. We received it a year later, Halloween actually, October 31st, 2022, which is when we received it. Mm-hmm. And then ever since then, we've been jumping through a lot of hoops, going over a lot of hurdles. All we want to do is get to the review part, which is where the justice looks at everything and says this was either correctly done or badly done.
Or ultra vires. That's the foundation of the judicial review is ultra vires, which means outside the scope of the authority. So the public administrator in this case, decision maker, is Robert Strang. He's the Chief Medical Officer of Health for Nova Scotia, and we are contending the orders were outside his authority. What was contained in those orders were issued outside of his authority. And so that's the basis for our judicial review, the grounds for review.
And they've since gone back to court as recently as January 25th in an attempt to get a public interest standing, something that would allow the organization to speak on behalf of all Nova Scotians, to challenge the overreaching government actions that are part of the original judicial review. While obtaining government records related to this case, the group was given 12,000 pages of the purported evidence used by the government to declare the provincial state of emergency and apparently justify the subsequent vaccine mandates.
The record was delivered a year after it was supposed to be delivered, and it was about 12,000 pages plus 7 gigabytes compressed of websites, NACI, the national
NACI statements, PHAC statements.
Yep, Pfizer, vaccine manufacturer inserts. There was some epidemiological data, but we kind of pulled some of those numbers out and did a spreadsheet, and all it showed was that there was no visible pandemic in order to justify the orders. Mm-hmm. So, that's just pulling out, and there was no in a public institution setting. One has to have, what's the right way to say it? You don't make a decision after reading 12,000 pages. You get somebody to collate them, summarize them, make a recommendation. None of that was included in the record.
Like many other COVID-19 related cases all across the country, the government has put forward a mootness motion, citing that because the restrictions are no longer in place, any arguments against them are moot or irrelevant, which is the next hurdle for CANS.
The government has put forward a mootness motion, and we're going forward with that. We are different than other judicial reviews in the country. We are still alive based on, we believe, the grounds for review, which is ultra vires, we mentioned before, mm-hmm. and which would be the resulting bad faith.
Now, when CANS discovered that Canada's state broadcaster, the CBC, covered their January 25th public interest standing hearing, they were shocked by the misinformation contained within the article, which has since been corrected, including getting the section of the Health Protection Act wrong.
We had to correct things like they said the judge decided to throw out public support letters, which I believe is the reason why this caught the attention of CBC, because there was public interest in this. Mm-hmm. They misrepresented what the judge said. The judge did not simply throw out the letters. He asked CANS what to do with the letters, and we said these are not intended to be part of evidence.
Right.
Therefore, they were not part of the hearing, which was always the intent. But the CBC article seemed to imply that we were considered, it was an inappropriate move, and that's why the judge decided to throw the letters out. Mm-hmm. So it was concerning the way they were trying to twist. And they were present. They were either online at the virtual hearing or in the court. So there's no reason why they should have gotten any of the quotes wrong, any of the sections wrong, mm-hmm. or any of the intentions wrong.
Right. And they're legally required to be reporting correctly.
And with a vast amount of resources at your midst and billions of dollars of taxpayer funds funneling to your cause, you would think that they could even simply request the transcripts to copy and paste. Is there anything that we didn't touch on here that you'd like to get across to either the citizens of Nova Scotia, Canadians as a whole, or perhaps a message for people on how to stay informed and take a piece of what you're doing here in terms of a government watchdog initiative?
The biggest message is that it's our government, and we need to make sure we stay engaged in it, because otherwise, if we're stepping back and allowing someone else to take the reins, then their goals and their agenda goes forward. What we need to do is take our countries back, our provinces, our towns, our cities, because it's happening on not just a health in the health realm. It's in all sorts of areas. Digital currencies, 15-minute cities. It's just communications, everything. It's a considerable onslaught that we have to be dealing with, and as much as we can, write back, write your MLAs, write CBC, write these. Just do it. Like, get engaged.
If you question the safety and efficacy of these novel injections and question the way in which they were pushed onto everyone indiscriminately, then please head over to our website at nomoreshots.ca and check out our reports there. You can also sign our petition and send a form email to Federal Minister of Health, Mark Holland, calling on him to revoke market authorization for these novel mRNA injections. All of that at nomoreshots.ca.